Okay, I'm going to introduce Sabrina now. Hi, Sabrina.
Hi, can everyone
Hi.
hear me okay?
Yes, we can hear you perfectly.
Great.
I just want to quickly introduce Sabrina Venskus, who I've known for a long, long time. She's been fighting for CEQA and represents all kinds of neighborhoods and communities who are trying to save something. Often the urban tree canopy has been one of her big fights in the LA area. Bad overdevelopment in canyons, all kinds of things. She's very, very knowledgeable and expert on CEQA. And she's been taking a look at SB 10 in particular and SB 9 as well, and how bad they would be for California. And she lives both in LA and Ojai, so she sees the countryside and the urban areas. And she's got an incredible grip on how politicians think, and she could probably she's got a PhD in how politicians think. So without further ado, Sabrina Venskus.
Hi, everybody. I'm excited to see there's so many people in this meeting today. And I'm sorry that I can't be on video, but I am in Ojai right now, and I get very bad service. So you just see my picture. So I wanted to talk about some major concerns with SB 10 and SB 9 from an environmental attorney's point of view. And the reason why I think this is important is because, well, I should say as an environmental activist point of view in the first sense, but then also just also as an attorney, some concerns that I have with, or that we as environmental attorneys, I should say, have with these bills. I'm going to just kind of focus on 10. But a lot of this crosses over, the general principles cross over in SB 9. So number one, with respect to environmental impacts, the way that I see SB 10 is it's an end run around CEQA by the state legislature. And actually, I'm not going to talk, I'm going to talk about the authors instead of the state legislature, because I want to acknowledge that there's a lot of legislators that don't even know about SB 10, that it exists, or what, you know, the substance of the bill. So I'm just going to talk about the authors of SB 10 and when I talk about it. So I think this is an attempt by the authors of SB 10 authors is an attempt to do an end run around CEQA, because what CEQA requires is discretionary review of any project. And project is defined in CEQA as something that needs discretionary review. So if you have a project that doesn't require discretionary review, it per se means that it's not a project under CEQA and therefore doesn't have to have CEQA review. So by deeming projects ministerial, or saying that a city or a county can pass an ordinance that allows development without discretionary review, you're saying you don't have to have CEQA review. The thing is that bills that are passed by the state legislature don't have to undergo CEQA review as per the CEQA statute. City ordinances, county ordinances, development projects that require zone changes, those all have to undergo CEQA review. So by the legislature saying, cities, you can do this thing, meaning you can allow by right all this development, it's basically the legislature that's lobotomizing CEQA, right? Without them, the legislature having to go through CEQA review to see how their law is going to impact the environment. So it's very sneaky. It's a way to undermine CEQA, any environmental review of housing development. That's number one. What does no discretionary review mean? What it means is that if a city passes an ordinance that allows up to 10 units on each lot, that ordinance doesn't have to undergo any environmental review. And what does that mean? That means the city planning department can't look at impacts to infrastructure as a result of allowing by right, for example, 10 units on each on each parcel, on a single family parcel, for example. They can't look at the impacts to whether or not there's going to be enough wastewater treatment capacity, whether there's going to be enough water supply, whether there will be enough staff at the fire department or the police to handle all that new development. That's a recipe for creating third world countries, third world countries in the state of California. Because you need to have decent quality of life, you need to have the infrastructure for people. So that is a major concern. And it's almost like we as environmental attorneys think, and I think a lot of people feel, that it's pure insanity. Why would you do that? Why would you do that to our state? So that the lack of looking at infrastructure. In fact, I joked with some colleagues the other day, and this is true. I had a nightmare. I woke up from a nightmare that the Hyperion wastewater treatment plant in LA, for those of you that are LA people, was overflowing into the Pacific Ocean. And I woke up and I realized, oh my God, that's because I've been thinking about SB 10, right? But seriously, these are the potential outcomes. It's completely insane. Another issue is, what about our urban tree forest infrastructure? If there's no discretionary review of these increase in density projects, that means that arguably, unless the cities, call it out specifically, other ordinances like tree protection ordinances would be overridden. And again, it would be all up to the cities and counties to decide whether or not they're going to, how they're going to draft their ordinances. But again, if they want to draft them in a way like Los Angeles sometimes does, to override any kind of environmental protection, they could do that. The other big concern that coastal act activists and attorneys have is that the coastal zone is sucked in here. The coastal zone, the Coastal Act, California Coastal Act, provides significant protection, not just for undeveloped coastal resources like Big Sur and so on and so forth, but also what they call in the Coastal Act special coastal communities. Those are communities that are the more diverse coastal communities that are special in their own right. And there's a few that were called out by the voters in 1972 and passed by the legislature in 1976 that are designated special coastal communities. I'm talking about Venice. I'm talking about, I think San Pedro is one. There's a number of them, Carmel, a number of them along the coast that are actually, they are by definition developed areas, but they're still deemed coastal resources that are to be protected because of their special character. And so this bill, as I read it, would overturn that, or I would say conflict with the Coastal Act. And what that would mean is that special coastal communities that are protected to preserve their mass scale and character would no longer be protected under this law, because these, for example, in Venice, these 150 square foot lots that currently can only handle, a unit or two or three would be able to go up to how many units, 10 units. So it destroys special coastal communities. The other thing is local agencies, I'm still in the Coastal Act now, local agencies that are within the coastal zone have to approve local coastal programs. They're called LCPs. And that's sort of a local agency's interpretation of the Coastal Act and how how they deem the Coastal Act will be applied and interpreted in their particular special coastal community or their area, their jurisdiction along the coast. And the idea is this: the idea is that each community in California is its own kind of special community. It has its own special characteristics and things that make it, give it a sense of place, and protection of their special coastal resources. And so I think there's a couple arguments with SB 10 here with respect to the issue of sense of place in California. It treats everyone the same, as if all cities are the same, as if all communities are the same. It creates a monolith in California. It undermines the principle in California, and I think especially if you could use the Coastal Act as a really great sort of illustration of this, it undermines the principle and the philosophy that we're own, California is made up of unique communities. And we like that, what am I trying to say? We like the differences, we like the differences. And we want to keep it that way. That's what makes California special. And so back to the Coastal Act, these local agencies have these local coastal programs that are approved, and they have to be approved by the Coastal Commission, by the way, the state Coastal Commission. I think that this bill, the way I read it, would undermine those local coastal programs and actually contravene them potentially, so that local agencies could basically say, well, our local coastal programs don't really apply because, we can pass these bills that allow by right 10 units, regardless of what our local coastal programs call for. That to me is just a huge morass. And I'm not sure if the Coastal Commission has weighed in on this bill, but I think for those of you that have any kind of connection with coastal staff, any coastal commissioners, you might want to put up a red flag for them, because I think this would just decimate, or at least throw a huge monkey wrench into the whole Coastal Act scheme of things with respect to LCPs. The third thing that I want to talk about is that I think is really important from a litigator's point of view, and I don't know how much any legislator is going to be able to sort of how much this is going to interest them, let me put it that way, is that the complication in a statute, when a statute is written in a complicated way, you usually look at it either it's the legislature was sloppy, or it was intended to be complicated. Now, when a law is written for the benefit of the government, meaning here for the benefit of a local agency, a city or county, the law will always be interpreted by the court to the benefit of the agency. Okay, so what that means is where there's complication in the law, such as here, it puts anyone who wishes to challenge the law or application of the law at an extreme disadvantage from a court standard of review perspective, because the courts will always, number one, if it's too complicated, throw up their hands and say, I don't really want to do the work to figure this out. And they're never going to say that, but that's how it really works, right? In principle, and realistically on the ground, that's how it works. And the courts will give deference to the city's or the county's interpretation, or the state's interpretation if it's a state law that applies to the state. So meaning that the deference to how you interpret the law will always be given to the government in these kinds of laws. So you've got a situation where you've got a very complicated law with arguably, as Jill pointed out, vague and broad terms that are, by the way, somewhat dependent on a completely different government authority here, the federal government's definition, which could change any time, by the way, right? That would ultimately, if this bill was ever challenged in court, or the actual application of the bill, right, to a development or to a city passing an ordinance using this bill, the deference is going to be given to the agency. And you're probably and when I say you, I mean as if I'm talking to my neighborhood organization client or my environmental, group client, you're probably going to lose. So the bill needs to, if it's a good faith bill, in my view, it's written in a very straightforward, understandable way, both for the legislature and the legislators that are going to vote on it, but also for the benefit of the cities and counties so that they can fairly interpret it, so that it'll provide for less challenge and, quite frankly, for the courts, ultimately, if this ever gets challenged, again, as a bill itself or as applied. I think, I just kind of want to end with, let these authors, the authors of SB 10, it seems to me, and just, I haven't read every single revision that's happened since it was first introduced, but based on my conversations with people at Livable, California, and having looked at, various iterations of the bill, it just seems to me that, when a legislator is acting in good faith to really listen to, criticisms of the bill and trying to address problems with the bill, you use straightforward language, defined terms. You try to take the vagueness out of the statute, and but when you find that there's these kinds of hidden, I'll call them treasures, where they're not really treasures. I'll call them bombs. It just suggests to me that, such as the U.S. Census, cluster? It just says to me personally that this person isn't acting, this author isn't acting in good faith. And I think, that's kind of 50,000 feet up. It's like, how do we get the legislators that aren't able to read all of these bills to get that they really have to focus on certain authors and their bills, because, they don't seem to be acting in really good faith here. So that's kind of, just sort of a general, I want to just make that observation, because I do think there's a lot of legislators that do act in good faith. And I think there are a lot of legislators that really are trying to do the right thing for housing and help us preserve affordable housing and create truly affordable housing. And they're really seeking to do what's right by the state and the cities and counties. But I think when you see these kinds of games being played by an author, I think that, they can't be trusted. That's just, and I know that there's people on here that are going to go and tweet and say whatever they want to say about what I've said, but, you just got to speak truth to power sometimes. And that's what I see. I just see a lack of good faith. And the legislators really need to look closely at this and understand the potential impacts of this bill. It's so sweeping and potentially so devastating to California as a place.
Wow, that's fantastic, Sabrina. I'm going to ask the first question because I'm unmuted. Ha ha, everybody. That is, he said three things at the hearing to assure everyone that his amendments had really changed the bill. And one of them was SB 10 won't affect you as long as you are not in a sprawl area. That's one of the ones you've dealt with. He also said some wildfire areas are exempted. We can't find the language of that in the bill. There's no additional protections that we can find on wildfire or fire hazard zones. He just repeats the existing law as it is already without his bill. So we can't find that. And the third one he said was, we removed open space from this bill entirely, entirely. So we took a look at whether he really removed and protect open space, because we have a list on Livable California website. Everybody should read it. It's called SB 10 Fact Sheet, and you can look it up on our site under News. And in that list, we talk about all of the many voter-approved local land protections in California. There's only 28 of them, but we haven't done full research. There's probably a lot more. Those are the ones we found. There's 28 of them around California where the local city voters protected land. And none of them are none of them will be saved by Scott Wiener's changes to his bill. He is only protecting public open space, publicly owned open space or public parks. And I'd like Sabrina to weigh in on that, because our list is all entirely, and we didn't know this until we went back to check a couple days ago, our list is entirely the protection of private land, such as agriculture, farmland, canyons, urban boundaries. All of the voters in California are very active in protecting private land from being overrun. So he made this big promise about public land. Sabrina, what do you think of that his promise, well, we're going to protect the public land?
Well, the thing is that public land is public land, so it's already protected. I mean, you don't usually have public lands unless they were for some reason made public in order to protect them. I can't think of any situation where you have public land, unless maybe you have, a public housing project or something, but then that's not open space. So I can't think of, and maybe I'm just not, it's too early in the morning for me and I'm not thinking creatively enough, but I can't think of any public land that you would have to protect. Meaning that it's in the public, it's already owned by the public. The public would have to, by virtue of the fact that it's public, the public would have to have a say on whether or not you're going to put housing on it, for example.
Okay, so does that mean then he's either doing a theater thing here, a kind of drama, or he doesn't understand?
Yeah, I don't know. I mean, it may be that maybe he doesn't understand. I mean, I guess, and then the other question is, well, what does he mean? You mean public land that's owned by the city and counties? I mean, there's also state public land. So, I guess I don't feel I have enough information to be able to say what I think that he thinks or what he's trying to do. But it just seems strange to me because, again, public land is not really what you're concerned about. It's that's where you're really going to get the pushback from the community. There's no, with private land, that's always what you're most concerned about, privately owned open land, because you have private property ownership, and private property ownership, these people have a certain right to develop their land, just depending on what the zoning code says. So, you as a member of the public, you own the public land, right? So you have a say in it. With respect to private land, you don't really have a say in what happens to that land. You can, for example, pass an initiative that says that you want to zone it open space, or you can pass a referendum that says you want to overturn what the city council did for that private landowner so that it goes back to open space, for example. But the public land, there just isn't the threat there. There's not the same threat. And I guess that's why it feels like a facade to me.